that might have logged into the wrong link while we get started. At this point,
Margaret, I don't mean to push back
yes.
right away, but I'm not entirely sure that we have a quorum. So
yeah,
we might
that's what I
only
was
be
just
able to
getting
do.
to.
Okay, many apologies.
That's what I was just getting to. So do I not officially call this to order since there's no quorum?
Technically, no, but we could still host the training. And then
Right.
I guess if another board member trickles in, we could kickstart the meeting then. And
that
perhaps
was exactly my thought. And just to convey, Mayor Newberry did have a medical situation that came up, so she is unable to join us tonight. I thought Catherine was planning on joining us. So Sam, we will go ahead and turn it over to you. And then if we do end up with a quorum after Sam's presentation, we can go back to the general business. So we can just start our training. Thank you, Sam.
Okay. Thank you very much, Mayor Pro Tem Peterson.
Can I ask a question? Does our training count if you don't have a quorum?
Yes, because this isn't an official meeting. This is training.
Okay.
We had business that we added on.
I've already done this twice in a year. I just don't want to have to do it a third time.
Well, thank you for the comment, and I think Mr. Light can kind of answer that concern for you, since it is a required training.
I'm getting a lot of emails from everybody who's on the other call.
Mayor Pro Tem Peterson, should I hold for a moment just to give people? It's fine with me. I want to be respectful of everyone's time, but I can also wait for another minute or two if other people need to join, whichever.
Sure, absolutely, if you're willing to do that. And Lenore, since you're getting emails, why don't you, if you could just respond back to them and let them know to go to the town website, since you've got direct stuff, that would be wonderful.
I'm doing it as we speak.
Thank
I just
you.
sent an email out to a group chain connected to the invite with the link, the password, the meeting stuff as well. Okay, let's see. There we go.
It's saying it's undeliverable. Matt, you sent it again, right?
I did
Yes.
send out an email just now to everybody with a physical link to this, as well as updated the Outlook invite. So hopefully they'll trickle in.
I'm in. I'm not on camera.
I hear you, David. We got you. And it looks like Catherine joined as well. So we can establish a quorum.
Wonderful. So since we have got a quorum established, if you don't mind, Sam, we'll just do our general business real fast. And now, with the quorum, I will officially call this Board of Trustees meeting to order at 7:11 p.m. So the first order of business is if everyone could please rise for the Pledge of Allegiance. And I actually found a flag. So, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. So now, are there any additions, deletions, or corrections to the agenda? Okay, seeing none, I'll move forward. Did we have anyone that had signed up for speaking?
I did not receive emails, but if there's anybody who would wish to speak, please speak up now. Cool.
Okay, so the next order of business, we have consideration of a special event permit application For Trout Unlimited and UPass Elementary School, do we have any representatives from either of those parties online here?
So I could speak to that.
Thank you.
And so I've been in contact with VP of Education. I believe her name is Michelle White. She had ran the event in 2019 and wanted to pursue the event again in 2020. Unfortunately, couldn't because of COVID, and then wanted to do it in 21. And again, unfortunately, wasn't able to make it to this evening's meeting, so asked me to present some information in her stead, which I'm more than happy to do. What Trout Unlimited and UPass Elementary School are looking to do is take 2 classes and have them go to Gazebo Lake and fish, learn how to fly fish. They'll have about 35 people there total at one time. And the only reason I really considered it for the special event permit process is because of the large donation of fish from Colorado Parks and Wildlife that Trout Unlimited has offered us, in addition to bringing the kids into the community. And with that in mind, town staff is recommending to approve the special event permit. And keeping with the 2019 event where they weren't charged to host the event, and keeping in mind the great donation of fish, staff is also recommending waiving the special event permit fee for this event as well. I also received some pictures from Michelle of the event from 2019. I figured I'd show you guys real quick as well. Clearly, they're very happy to fly fish. And from all accounts of Michelle, it was a very successful event. Kids learned a ton and really seemed to enjoy it. So I'm excited to bring it back in 2021.
Okay, wonderful. Thank you, Matt. Yeah, fishing is great no matter what. Now, one question I have as far as liability, who's responsible for insurance, and will they have that in place in time for the event?
Yes, so great question. I dug into this more today to get some specifics. Michelle is sending me a certificate of insurance, hopefully by tonight, if not by tomorrow morning. And Trout Unlimited is the insured in this case.
Okay. Sorry, I'm writing notes. Okay, so board, do you have any questions or any comments?
No, it sounds like a great event. I'm glad that, with everything going on with COVID, that they're able to do these types of events now. So it sounds like, it sounds like a great one.
I agree. I agree. So Catherine, do you have any comment?
No, sounds like a good event. Let's do it again.
Okay. So can we have a motion to approve the special event permit and waive the fee in lieu of donation of fish for the lake? I don't know. Did I ask or did I just make the motion? I don't know.
That's what I was wondering, yeah.
I'm trying not to show you what a rookie I am at this part of the meeting.
So I guess I'll move to approve the special event permit, waiving the special event fees for the Trout Unlimited event.
I'll second that.
Perfect. All in favor?
Aye.
Aye.
Aye. Okay, motion passes. Now, Matt, one thing, if you could please reach out and just give them a quick little reminder about the geese that are in town around the lake.
Yes.
I'm sure Public Works will be able to give the park a really good rake prior to them coming, especially if we get that on the calendar. But just so that they're aware that the geese are around and they kind of have a mess sometimes. So just to be able to anticipate that.
Certainly, we'll do. And Angie and I have been in talks with Public Works already about taking care of the lake for the kids as well. So we'll get it moving.
Great, thank you. Okay, so now, Sam, it's your turn. We're moving on to our annual training. So now I'm going to pass the baton to you this time, and I'm not taking it back, okay?
Okay. Okay. Well, I'm at your pleasure here, Mayor Pro Tem Peterson and board. So if you want to take it back at any time, just let me know. Thanks very much for having me, everyone. Can you hear me okay?
Yes, sir.
All right. Well, thanks for inviting me down virtually to visit with you all. I wish I could come down in person, but we'll look forward to that opportunity soon. I think I've gotten better. We've all gotten better at virtual meetings, but it's always nice to have an opportunity to meet in person. So maybe our next training will come down in person and I can bring swag or snacks with me at that point. But for tonight's training, I'm glad we can connect virtually and look forward to our discussion this evening. So I'm going to share my screen in a minute and go through some PowerPoint slides for my training material. I do want to make the training as helpful and useful to everyone as possible. So if you do have questions as we go along, feel free to ask and do whatever's the most appropriate means to get my attention. If Matt can help me and monitor the chat box, then if a question pops up there, please feel free to jump in and ask me a question as I go through the materials. I know that some of you have attended my training, one of my trainings recently. I think I visited last spring. I am going to touch on many of the same topics, but with some slightly different twists to it. And if we go through those and there's been a thought on your mind about some issues or topics that we've covered in the past and you want to explore those a little further, just go ahead and ask and we'll cover that. So let me share my screen here, Matt, and we'll get started.
Sounds good, Sam.
All right. I think everybody should be able to see that okay, right? Good, Matt?
Looks great to me.
All right. So my training is called Suggestions for Success for you all as elected and appointed officials. I know we have members of the board here tonight, and I think we also have members of the various town boards, commissions, and committees. So welcome, everyone, and thank you for having me. I call it for Suggestions for Success because I'm going to focus on kind of civics issues and how to do our job effectively as town officials. And by that, I mean by the leadership group, right? The town officials consisting of the legislative body, that's the town board, right? And then its advisory committees, which help formulate policy and plans for the town. We'll talk later about the policy and administrative distinction, but I'm tonight focusing on a presentation for you all as elected and appointed leaders of the community. I find that if we focus on suggestions for successfully doing our job, then by and large, the liability issues are going to take care of themselves. As a presentation overview, I'm going to talk about the role of being a public official because you do take on certain responsibilities, both legally and ethically as an elected or appointed official, but you also take on responsibilities to each other. We're going to talk about transparency. Being in the public sector and being a public official is a lot different than being in the private sector. And there are expectations and legal requirements around that you need to commit yourself to with respect to transparency. I'll give you some suggestions for running good meetings, both internally as a board working together and also outward looking about how you deal with citizens, applicants, public comments, those kinds of things. We're going to touch briefly on your ethical obligations. I need to always check in with you and give you suggestions on how you deal with issues like conflicts of interest and so on. And then we're going to talk about the town's structure and how everyone within the organization needs to understand, appreciate, and commit to their role within the larger organizational structure, because everyone in the organization does have a particular role in order to function at a high level and succeed and be firing on all cylinders. As a public organization, it's important that people respect their particular roles within the organization. Our executive director, Tammy Tenoy, has analogized it to everyone has a lane, right? And you see those commercials of, hey, stay in your lane kind of thing, right? That's an important aspect, both from a liability standpoint and from functioning at a high level as an organization. And then finally, I'm gonna, particularly for the planning commission members, if we have some here, and for the board and for the Board of Adjustment, I'm going to talk a little bit about due process issues, but it's worth listening to no matter what board or commission you're on, okay? A caveat that I always make is please understand that though I'm the general counsel for CIRSA, your insurance provider, and I am an attorney, this isn't an attorney-client communication. This is simply a training resource for you all. So if you need legal advice on any particular matters, that's for your town attorney, not for this particular session, okay? All right, I know it's very hard virtually to have people raise hands, so I'm gonna skip over that part. But if you're brand new to public service and you just got appointed to a board or commission or committee, congratulations, welcome, thank you for your public service. If you alternatively have been involved in town government and been on a board or a commission or on the town board for a couple of terms now, it doesn't matter whether you've been there just a couple months or for a dozen years. I think it's always important to check in and remember that when you become a public official, right, you become a government official, right? You're no longer a citizen only of the town of Green Mountain Falls. You're a public official. It's kind of a 24/7 job, right? By that, I don't mean, you're not asked to give up your personal life. And of course you have a personal life. But once you become a public official, when you interact with each other, with citizens, with outsiders, right, and you're talking about town business, right, those people will always perceive you as being a town official. And as it should, when you're a public official, your words, your deeds, the way you present yourself, the way you conduct yourselves will always reflect upon you and always stick to you as a public official. Sometimes it has potential liability consequences, but most importantly, day to day, understand and appreciate that in the eyes of the community, once you become a public servant, when you're dealing with town issues or talking about town business or being asked about town business, they're always going to perceive you to be acting as a representative for the town. Recognize now that once you're on the inside of the town government, you really are an insider. And the ways that the town does business, right, you are bound to follow those ways of doing business. Your board or committee or commission has bylaws or rules of procedure. You're obligated to follow those. Your board or commission or committee has an ordinance that says, these are the powers and duties of our board or commission. And that is your role within the organization. It's important that you honor that and understand that as an insider, we're all duty bound, right, to follow the town's ways of doing business and approaching issues, okay? Recognize also that in that same vein, it can be very dangerous or destructive to your board or committee or commission if one or a small group of the members take kind of an outsider's view of things and say, the bylaws, I don't really have to follow those. Those things don't stick to me. Or you can do what you want because I don't have to do that. Those are all incorrect assumptions about what it means to be a public official and part of a collective group. So be careful in that regard. Recognize that when you became a town official, I know that the trustees stand up and affirmatively take an oath of office. I swear to uphold the Constitution and the laws of the state of Colorado and the ordinances of the town. But whether you actually do that formally, right, or not, when you're elected or appointed to be a public official for the town, you do make the same commitments, right, that any other public official takes when they assume office, right? You make a commitment to various things that have legal meaning, ethical meaning, moral meaning, and I think also kind of a fiduciary meaning or responsibility to each other. By that, I mean, for example, when you became a public servant, you made a commitment to respect your role, right? And your responsibilities within the town structure. You made a commitment to lawful conduct, to following the ways that the town is established for doing business regarding bylaws or how you conduct your meetings or what authority you have, to follow the criteria that apply in making decisions. You've got a lot of ordinances on the books, right, that help guide how you make decisions. And you're bound to follow those particular criteria. You, of course, when you became a public official in Colorado, you became subject to the Colorado State Code of Ethics. And I'll give you a little bit of information on that. And then finally, maybe it's not as succinct as some of the other points, but I think when you become a member of a board or a commission or a committee, remember that you become but one contributing voice to that board. But at the end of the day, the board speaks with one voice, right? It's what are we as a board going to do? What are we as a committee going to do, right? And success then means building consensus. Sometimes success happens by a 4-3 vote or a 3-2 vote, right? Sometimes it's a 5-0 vote or a 7-0 vote, right? But whatever it is, part of the job is working together, right, to articulate the voice of the board or committee or commission. And I think that means that part of the job description is really a commitment to at least professional courtesy and respect for each other's divergent viewpoints and styles. Absolutely the case that you're going to have debates and disagreements, right? But we can have disagreements without being disagreeable, right? And we can all contribute our voice in a respectful manner, always working towards the voice of our board or committee. And we'll talk a little bit more about that a little bit later in the presentation. Recognize that when you become a public official, you're part of a collective decision-making body. But as I mentioned earlier, that body speaks with one voice. If it's a 5-member body, it doesn't have 5 different voices when a decision is made or a recommendation is made. It has one voice in that regard. Each of us contributes to what we think that voice ought to be. We offer our own perspectives and opinions, right? But ultimately, once we're ready to develop the committee's recommendation or the board decision, that's a decision that's made by we as a board. From a liability perspective, I want everyone to appreciate that, you know, though we have a 5 or 7-member board, right, you don't want to misperceive that you have a fraction of that power. Like if you look at your bylaws or your committee description, it always says, this is the role of the committee. This is the role of the board. Its powers and responsibilities are exercised collectively as a board or as a committee, right? You might be thinking, well, you know, we got a 5-member committee here, and I'm one of those 5, so I got 1/5 of that power, and by darn it, I'm going to go out and use it, right? It doesn't work that way either legally or as a responsibility to the organization. The power and the authority and the voice of the committee or board belongs to the board, commission, or committee itself. So it absolutely must mean, right, from an individual contributing voice perspective, that success is dependent upon collaboration and trying to get your fellow members to come along with you and think in terms of we and not I. Let me give you an example of where that can be destructive and potentially create some risk issues. Let's say your board committee, you've got your work plan or your plan set out for what you're going to do over the next couple of months, but I, as a member of the board and commission, say, well, I have my own particular idea about the one item that I would like to see us spend resources on and put our energy on as a board, right? But I'm just one person. If I can't find at least a couple other members to come with me, right, then that issue is not going to go very far, right? And if I go to the committee meeting and I say, hey, I'd like us to take up this particular issue, if the discussion that ultimately comes out of that is it's not a priority, it's not on our work plan, let's think about that next year, then as an individual member, I have to honor and respect the will and goals and plans and priorities of the group as a whole. It really means I have to put my own particular idea on the shelf in service of the larger voice, right, of the board or committee, okay? Last thing on this suggestion is, and we all know this, but part of your job duties as a public official is to deliver good governance, right? And I think that practically and legally, and from a risk standpoint, it depends upon honoring a couple of key civics concepts, which I put up on the slide here. I think that if we focus our energy on committing to these core civics concepts, then by and large, the corresponding legal issues that I'm circling now, those are going to take care of themselves. Yeah? So by that, I mean, if we commit ourselves to openness and transparency, we're going to have few, if any, problems and claims under the Open Meetings Law or the Open Records Law. You know, in that regard, for example, do we recognize as a public official that the emails that we send that concern our role as a public official or that concern public funds, those are by and large public records, right? And that's probably true of tweets and texts and all sorts of other things, right? Any communication that we send as a public official is potentially a public record. There are some exceptions there, but not many. So it always means, I think, in terms of transparency, to use the appropriate tone and temperament and stay on point when you engage in electronic communications. Commit yourself to fundamental fairness, right? And if we do that as an organization and as individuals, then our town and us as individual public officials, we're not going to be subject to many claims under the due process clause. By the way, a violation of due process can attach to both the town and to the individual public officials who deny someone their proper due process. So it's important to have a fair process with everyone. Be predictable as well, right? Sometimes that can result in risk issues and potential claims. For example, if you have a process for approving licenses, right? Those licenses have to be considered consistent with existing criteria, right? You don't want to be a community that is perceived as changing the rules on the fly or reinterpreting those licensing criteria in the middle of an application. Those are the kinds of things that lead to equal protection challenges or to claims that what you're doing is arbitrary, right? So you want to be predictable and consistent and even-handed in how you do your business. And then I found over the years in doing these presentations that a huge predictor of risk is this simple civics question. Do we treat each other with mutual respect? Commit yourselves to mutual respect, and I think your risk profile will go way down, and your success as individuals and as a board or committee will go way up. And that's mutual respect with each other, on your body, mutual respect with citizens that come in front of you, mutual respect with staff. Because, and I get it, I was a municipal attorney for 25 years before I joined CIRSA. I sat through a lot of tough meetings, right? But I found that if the people in those meetings, right, were approaching each other by listening with mutual respect, giving each other the benefit of the doubt with respect to process, being empathetic from where people were coming from, that people would go home from that meeting. Yeah, they would still go home from that meeting and think, you know, the people who didn't like the ultimate decision might be thinking to themselves, well, you know, I'll never agree with the board on the actual decision that they made. But you know what? I feel like I was heard. I feel like I was respected. And I feel like it was a good process. That's a great place to be as an organization, both in terms of trust, community trust, trust in one another. And it's also a great place to be from a risk profile, because we found over the years at CIRSA that things that come to us as claims, a lot of them have underneath them this kernel of something was jacked up about the process, or I was disrespected, or it was a decision that was already made before I got in there. I didn't feel like I was respected, those kinds of things. So committing yourselves to mutual respect, I think, is a big, big plus in reducing risk and succeeding as an organization, okay? Let me move on to transparency issues. Do everything you can as an organization consistent with the resources that you have to be transparent. That'll serve you very well. It builds great trust with the community. Just as one example of that, I was looking at your website. You know, your citizens appreciate transparency in terms of having information at their fingertips, right? So from where you sit as an elected official or appointed official, if you have a citizen that comes to you with a question, you know, if we as an organization, particularly if it's a something for which there's a lot of community interest, if we can be transparent in making information available through staff and the website, that'll serve you well, because then you have a place to send citizens and say, hey, we understand there's a lot of public interest in that project. You can go to our website and see the current status, right? And I thought you had a great website. It's a great thing. You know, your meetings aren't always packed, but part of the reason why is that if citizens feel like they have a trustworthy, transparent way, right, to find out what your board or committee's up to, then that's a good thing, okay? All right, I need to touch base again, and I think one of the people said that they've been to the training recently, and I know that I covered this in prior trainings, but I need to cover it for everyone, is I want to make sure we all understand what our obligation is under the Open Meetings Law, okay? That's the Colorado statute that applies to all public entities, including the Board of Trustees, the Planning Commission, the Board of Adjustment, every board and commission of the town. And it requires that our discussions of policy matters happen in open public meetings. So very basically, the Colorado Open Meetings Law says this. It says that whenever 3 or more members of your board or commission have a discussion of public business, that's a meeting that has to be open to the public, which simply means a citizen has the right to observe that discussion, okay? The second part of the state statute is if it's a meeting at which you're going to take some kind of action, then you have to have notice and an agenda posted in advance, okay? That's really the main rule that everyone needs to understand and appreciate from where you sit, right? Recognize that a meeting, right, includes, for purposes of those rules that I just mentioned, that includes any kind of gathering, whether, you know, like we did in the old days in person at town hall, right? Or by phone or electronically like we're doing now, right? So even for electronic meetings, chats, if it's 3 or more members of the board or commission having a discussion of public business, that has to be an open meeting. By the way, one thing is a note of caution. When I say 3 or more, right, that assumes that the board is at least 5, right, members and all the seats are filled, right? If it's a committee of 3 individuals, right, then the rule actually applies to 2 people because that constitutes a quorum, okay?
Hey, Sam.
People ask, well, all right, we're a public body. We got a public meeting, but can we go into private session to talk about things privately? The answer is perhaps, right? But only under the rules under state law that allow you to go into an executive session. I suspect your board does that, right? On occasion, Angie, but the Planning Commission, Board of Adjustment, you other folks, you probably don't have executive sessions much, if at all, right?
Very rare for another board to do it. We do have
Okay.
a question in the chat for you when you're ready, when you get to a
I'm
good
ready.
place.
Yeah, absolutely.
Okay. David, you said you have a
Yep.
question, but what is
Yeah.
your question? You're welcome to unmute if you like.
I think I'm unmuted.
I can
There
hear
you are.
Hi, David.
Hi. So we had a situation recently that I want to get clarified. I'm on the Fire Mitigation Committee, and we're really a fairly new committee and getting started. And we have a committee of 5.
Mhm.
And each one of us have taken sort of an area of responsibility, if you will. And some of the areas of responsibility involve reaching out to other government agencies. For example, the Colorado State Forestry Service, because they are a source of information. And so in order for us to do our job on the Fire Mitigation Committee, we need to have meetings with, like CUSP, one of the organizations about forestry, the CSFS. And so one of our committee members arranged to have them come in and talk at the pantry just to help educate us a bit. So the issue became, okay, is that a public meeting? Is that should we have posted an agenda? And, from my perspective, we're just gathering information here so that we can do the business of the Fire Mitigation Committee in a public meeting. So, I mean, to me, there's an education or a fact-finding aspect, and then there's the meeting to really talk about policy and developing policy, which I agree should be public. But I mean, when you're just out gathering information, where do you draw the line?
Yeah, it's going to be very fact specific from a legal standpoint, but I'll ask a question this way just to kind of cut to the chase on the practical part of it. So for those kinds of things that are educational, are our committee members actually participating in that educational meeting in terms of discussing a policy issue of the committee? I think it's one thing to go and attend passively attend an informational session that's actually run by another organization. But if you go there and then a couple of members of your committee start asking questions, and then there starts to be a free-flowing dialogue, and one of the issues in the mix is actually one of the issues that's pending in front of your committee, you can see how you can backdoor into an open meetings issue, right? So
That's way too vague for me.
yeah, I know it's vague, but that's the law. People always, sometimes it's a little frustrating being a lawyer too, because lawyers, they look to lawyers for give me a black and white answer. Sometimes it's areas of gray, right? The short answer to your
Well, I don't think that any of our committee members want to be breaking the law, but at the same time, we don't want to be so encumbered by the bureaucratic, morass that we can get a job done.
Yeah, the short answer to that question is if you go to that other state agency's educational meeting and you're participating in the discussion and there's 3 or more of your committee members there, then you ought to post that as a meeting of your committee. And that's my recommendation.
But only if it's 3 or more.
Yeah. Or if you got a 5-member committee?
We have a 5-member committee.
Are all the seats filled right now?
Well, we have 1 opening.
Okay, well, there's a little trap under your own ordinances. It basically says that a majority of the appointed non-vacant seats are constitute a quorum. Now, so for you, it's still 3, but let's say you had 2 empty seats. Then if 2 people went to that meeting, you'd be triggering the open meetings law. I know I'm getting in a little bit in the weeds, but your town clerk's going to help you with that, right? But I just wanted to point that out to you. So I could actually give you a little bit of a war story. I think it's worth taking the time to do that because this is where I can give you some clear guidance. So this exact situation came up between a board of county commissioners and a state agency, okay? And we probably should have known that it was going to be a little interesting situation because the place where the meeting occurred was actually at a restaurant called The Hideout. So it's sort of ironic, right? But what happened was the state agency said, hey, we're going to be down in your county and we're going to give a presentation, information only, educational presentation on the status of this mine in your county. We're going to tell you if they're in compliance with their mining permits. We're going to give you an update on the things the state is doing to get the mine waste cleaned up and so on and so forth. What happened is the Board of County Commissioners, several of the commissioners went to that meeting. And then the local citizen watchdog said, hey, I saw that there was a quorum of county commissioners over at that meeting at the restaurant. How come that wasn't noticed as a Board of Commissioners meeting, right? How come I didn't see on the door at the county offices a notice saying that the Board of County Commissioners was going to have a, quote, meeting, right? So that issue was litigated all the way up to our Supreme Court. And the answer to that was the Board of County Commissioners didn't have to post a meeting notice because they were able to show that the only thing the commissioners did was go and attend and listen. They didn't have a discussion amongst themselves of anything that was in front of the county commissioners. So I hope that helps you, David. I think what it means is, in answer to your question, is that technically you don't have to post a notice if you're simply going as members to some educational activity sponsored by some other agency, but you have to walk the walk. If you go there, but the 3 of you, digest all that information and then turn to each other sitting around the table and start saying, hey, this is how that information relates to our pending plan. Now you're having a discussion of your own business, right? And you can trigger that statute. Okay.
So the answer is really, we just need to make sure we don't have the 2 people there.
Right. Or just save your discussion. You can have the whole board go, but just save, as you hit on so nicely at the beginning of your comments, you can have the whole board go to an educational session. Like, I don't know if this is true of your board of trustees, but many towns have their entire board of trustees go to the CML conference, Colorado Municipal League Conference. That's not in and of itself a violation, right? It only becomes a concern when 3 or more of them start having their own discussions of their own town business, right? Without making that meeting open to anyone who wants to listen to it. So if you could have your whole board go, just save, as you so elegantly said, save your policy discussions for your duly noticed, right, meetings occurring back at the town offices.
Okay, thank you.
Yes, sir. All right, so executive sessions, I don't think are.
Hey, I'm sorry to interrupt you again. We had another question in the chat.
Yeah.
The question was, can you also clarify what the conflicts are with officials discussing policy issues on Facebook comments? This was from Trustee Lou.
Yes, thanks, Trustee Lou. So the same issue, the same underlying rule applies. Remember, the statute says that if 3 or more members of your body, in your case, the Board of Trustees, right, are having a discussion of public business, that can occur by electronic means, okay? It doesn't often get squared that way, but I can tell you, know, if 3 or more of you are getting on Facebook and you're writing comments underneath some thread, and part of your intended audience for those comments is your fellow trustees, then I think someone, right, perhaps rightfully so, could say, wait a second, I see trustees having a discussion by Facebook. Doesn't that implicate the open meetings law? Now, I've heard people respond back to say, well, it shouldn't be a concern because it's open. That discussion's open. Oh, wait a second. What if the settings on Facebook are such that I heard about the discussion as a citizen, but I actually couldn't see it because I was blocked? Or some participants to the discussion didn't have their settings so that I could be a part of that thread. Now you see where the issue lies, right, in that regard. So it very rarely comes up, but I think it would be a problem under the statute if the Facebook commenting was going on between 3 or more public officials and they were directing the comments to each other about pending policy issues going on in front of the town. Does that answer your question? Do you have a follow-up on that?
Yeah, no, I think that helps a lot.
Okay. Very good. One final word, though, on executive sessions for the Board of Trustees. When you are getting ready to go into executive session, make sure that you follow the procedural rules to a T, right? You have to announce the topic, you have to state the actual citation to the law, and you have to give further information about what you're going to discuss in the executive session. Your clerk and manager are going to help you through that process, but don't short circuit that, and make sure your record's clear. Who made the motion? What exactly was the motion? Have we got everything on record? I know sometimes executive sessions are late, and sometimes there's a temptation to say, oh, I'm moving on to executive session second, let's go. That's not proper. You need to make sure you follow all the procedures. So, okay. I think we touched on a couple of my scenarios already, but I thought another way to kind of illustrate your obligations on the open meetings law is to kind of point out a couple areas where you can break faith with the open meetings law. Obviously, right, if the obligation is, as it is, that your discussions of public business have to be open to the public, right? And if 4 or more are going to be attending, you have to have notice. Then of course it's not proper under the open meetings law, for example, to say, hey, I know the meeting's at 7 o'clock, but let's all meet down at the local restaurant at 5 o'clock and we'll go through the agenda and talk about how we're going to vote. That would be improper, would be contrary to the statute, right? Trustee Lou's question, I think, hinted at this in terms of Facebook, but remember, a meeting for purposes of the statute includes any meeting by electronic means. So if 3 or more of you are discussing town business by email, by chat, by text, right? The intent of the statute and your obligation is to make sure that that discussion is open to the public, right? It doesn't matter that no one from the public is there, right? Or that they want to speak or not. It's your obligation to set up those meetings so that they are open to the public if the public wants to observe the discussion, okay? The other thing I see every now and then is people will say, well, we've got a 5-member board, but we got a little bit of a topic going on, you know, and it might be an easier discussion or easier to resource this topic if let's create a committee and let's have 2 of our members be the committee and let's have them tackle that issue and they can meet and hash it out, right? And they won't have to do that in a public meeting setting. The answer to that is, in my humble opinion, is that wouldn't be proper. If you as a board or a commission are going to create a committee, right, then you're responsible for the thing you create. And the statute says that the openness requirement applies to every local body that has some role in the policymaking process. So if you create a committee to have a role in that process, then that committee needs to follow the open meetings law as well. Your actual ordinance on boards and commissions makes that very clear as well. Okay. Any further questions around the open meeting stuff?
Yeah, Sam, I had a really quick one,
Yeah.
and it's more conceptual than practical, but how has open meeting law changed in the era of COVID and with transitioning to Zoom? Has that influenced anything in open meetings law?
It has. It's put some technological burdens on folks to make sure that things are open, but I think we've tackled that. You've all done a great job of being able to set up your meetings so that people have a link, that if a citizen wants to link and see the meeting, they can do that. There's been a lot of questions about how to, in the age of virtual meetings, how should we handle public comment, right? And things like that. And among the techniques, I'm not super technologically savvy, but can we have people in a waiting room? Can we mute people? The general answer to that is yes, as long as people who are in the waiting room can still observe the discussion that's going on, right? And yes, you can mute someone with this huge caveat: never mute a person, right, because of what they're saying, right? You don't censor people for the content of their speech. There are a couple of exceptions. If it's a true threat to inciting riot or it's pornographic speech, then yes, you can mute that. But otherwise, we don't mute people because of the comments, however disagreeable their comments may be. And I'm going to get to public comment periods in just a minute. So I think it's okay on Zoom to have systems in place for a waiting room or to require that folks raise their hand. It helps the presiding officer maintain order. I think where things can break down is if you're the presiding officer and then you work with your staff liaison or your clerk to figure out what we can say in advance or at the outset of the meeting so everybody participating kind of knows how it's going to work. And that goes a long way to helping people understand how the flow of the meeting is going to work. It also helps you all as a board get your work done more, right? Because then you told everybody up front, hey, there'll be a chance for public comment on this or that issue, but here's how it's going to work, right? The clerk's going to have you in the waiting room, and then when it's your turn, we'll unmute you, and then you come in and you've got your 3 minutes or whatever it is for your comments. So is that helpful, Matt?
Yeah, thank you very much, Sam.
Yep. Okay. A related question on open meetings. When you exchange emails with each other as public officials, recognize that those can be public records, even if they're not triggering the open meetings law, right? So if I'm having a one-on-one discussion with a fellow board member about our budget, well, I'm talking about the expenditure of public funds, and that clearly is a discussion, a writing, even if it's by email, that's a public record. And so I need to understand that any citizen can ask for that kind of email, and we're obligated as an organization to give them a copy of that email, right? Your emails as public officials, by and large, are public. There are some exceptions, like if it's an attorney-client communication, or if it's a very sensitive email from a constituent, not a very sensitive email back and forth to each other. And I've had many elected and appointed official tell me they were unhappy that I told them we have to release a particular email that had some uncomfortable comments that they made in it, but that was the requirement. So make sure you're circumspect in your use of email. To me, it boils down to this. Don't say in an email anything you wouldn't want to say in a public meeting or anything that you'd want to see on the front page of the paper, right? Or anything that you would want read back to you in a deposition if, heaven forbid, you ever got pulled into a legal proceeding where your emails, right, were part of the relevant evidence. That can be an uncomfortable spot. So whether the lights, on that communication right at the time, sometimes it doesn't feel that way. Sometimes we get home from work and it's very late and we're trying to catch up with our public business, and that's when we respond to constituent emails. Remember, the light is probably still on that email, even if it doesn't feel like it at the time you're sending it. Okay. Let's see.
Sam, I have one real quick question. I'm sorry.
Hi.
Can you clarify is this for elected officials only, the Board of Trustees, or is this for all officials of the town, regardless of what committee they're on?
In my opinion, it's for all officials regardless of the committee. For elected officials, the statute certainly drives home the point quite clearly, because it says that if elected officials use email to discuss public business, then those emails are subject to the open meetings law, right? But the open records law says that any writing by any public employee or servant that concerns their job as a public official or that concerns public funds is a public record. Yeah. So I think, you know, in the practical world, we see more open records requests for emails between members of the town board or the city council, because they're the ultimate decision makers. But we've had many a situation, particularly like in land use or very controversial plan adoption processes, where people will say, well, I'd like every email that anybody in the decision-making process wrote about this issue, whether they were the final decision maker or not, right? And so, yeah, if you're on the Parks and Trails Committee, you know, you have an advisory role, but if people want your emails where two of you talked about the Trails Master Plan, then in all likelihood, that's a public record and you would have to provide that to the clerk so it could be provided to the public records requester, okay? Does that answer the question, Mayor Pro Tem?
Yes, thank you.
Yeah. Just one last piece. I just want to close the loop on this. Sometimes people ask me, well, wait a second. You know, if I'm sending an email from my home computer, well, that's a personal communication. And the answer is no, it doesn't matter what device you prepare the email on. If the actual content of the email concerns you performing your role as a town official, then that's going to be a public record. It doesn't matter what device you put it on, right? So that's all the more reason, right? If you're if you want to kind of guard yourself from intrusion into your personal computer, right? Then copy your staff liaison. You should be doing that anyway, right? Because they're there to support your board or commission, right? But also, do you all have town assigned email addresses? The board members do, right?
Correct, the board members do. I'm not
Yeah.
sure about the members of the other committees right now.
Board members do. We can't afford to purchase one through the through our IT servicer. It's about $5 or $10 a month, I want to say, per email address per year.
Yeah.
It would definitely take the cost up, but I mean, it's something that we could certainly look at during our budget process this year. But it is good to have. I hear from a legal standpoint, it's good to have a separate email account for your town business. Is
Yeah.
that something that you hear as a best practice, Sam, or what is your thoughts on that?
Yeah, we have members that, for the budgetary reasons that you mentioned, they're not able to get a town email address for every appointed official. You know, if it's possible, that's probably a good way to go, because then appointed officials can use that email for all their official business, and it's easier to spot, and it's less effort to go through your personal emails to figure out whether I sent an email about town business that I need to turn over because we have a records request. But you can get to the same end result by just heeding this advice if you're on an appointed board. If you are communicating by email regarding town business, just make sure that, you know, I'd suggest just keep it completely separate from anything personal, right? Just have, and you might even create a folder, right? Where you can just put those emails after you send them. By the way, you don't have to keep them forever. Routine emails are what we call just standard correspondence. And if it doesn't have any lasting value, then they can be tossed out after 30 days with one huge caveat. If your attorney tells you don't throw anything away, then don't throw anything away, right? So any other thoughts or questions on emails? Okay. Very good. I
There's
do.
a comment. Sorry,
Oh, I'm
Sam.
sorry.
There's a comment here. It's asking about text messaging as well. This does apply to text messages or any electronic communication or messaging. Is that accurate?
Yes. Yeah. Yeah. Both under the open meetings law, a meeting can happen in person, by phone, or by any electronic means of communication. And on the open record side of it, the statute says that a public record includes any type of writing, whether in hard copy or digital form. At the end of the day, the critical question is, does this communication or discussion relate to the performance of my duties as a public servant, or does it involve public funds? And if the answer to either of those is yes, then the meeting rules and the records rules come into play. I will give you a war story that's concerning to me as the attorney for the risk management, but more concerning for you because I don't want you to be on the receiving end of this criticism or heaven forbid, potential claim, is I've seen this trend of, I'll give you a scenario. You got a city council sitting there at the city council meeting and they're considering, I don't know, a rezoning request. And it's clear just to the naked eye that people have their heads down and they're on their phones. And we come to find out that they're texting each other, trying to convince each other to vote yes or no on this rezoning. Does that sound transparent? Where should they be trying to convince each other to vote yes or no? In the open meeting, right? So I've boiled it down to don't have an illegal meeting within a public meeting, right? It sounds bizarre, but I've seen it happening, and it's, if we just step back from this and think about what's going on here, right? You can see, and my concern is, you can see that you're going to be on the losing end of a transparency claim, but just as much, it's going to be quite embarrassing and significantly erode community trust if that's the way we're doing business, right? If we're having secret meetings within meetings, or we're have to appreciate and love, and I want you to, because it's why we appreciate your service, but you have to embrace and appreciate the fact that when we deliberate and we talk to each other about public business or what we want the decision or recommendation or vote to be, we have to do that transparently in an open discussion with each other, and we can't use surreptitious means to get to that end, okay? Suggestion 3 for you all is run great meetings. As you all know, right, having a great meeting just doesn't happen by happenstance. It takes some planning and thought and preparation in terms of getting ready for the meeting, reviewing our packet, coming prepared with questions that I may have regarding the items that are being put in front of us for discussion, focusing on what's the question for us as a board, right? What's the policy matter on which we're being asked to chime in, or what's the particular action item or legislative item that we have in front of us. And I know that no matter how large or small your entity, you got a lot of issues going on. Every municipality's got massive amount of public business they got to take care of, but your agenda is there to help you, right? You don't have to eat the entire elephant in one sitting. And that's what the agenda is helping you do. And it's helping you use we're all citizen volunteers, right? It's helping us manage and use our time efficiently by focusing on the agenda items and on the decision items or the direction items that are on the agenda at that particular meeting. That's where you want to focus your energy. There is a risk aspect to that, and here's how it unfolds sometimes. We'll get to the meeting, we know what the agenda items are, they're items A, B, and C, but we get to the meeting and one of us says, yes, Madam Chair, during the approval of the agenda, I'm sorry, but I forgot, I've got another item. And I think we need to add that to the agenda. Can we do that, right? The risk issue there is, one, is that transparent, right? Because no one knew that item was going to come up until just then, right? And two, then are my fellow board members prepared to talk about this? Is staff prepared to provide good information about this, right? In terms of the risk, I strongly suggest that you don't add new items to the agenda and don't take up new issues that aren't on the agenda the night of the meeting. I think a good way to frame it is what I call the empty chair principle from a risk standpoint. If I'm a board or committee member and I've got the thought that I'm going to add this to the agenda, you look out in the room and you say, or now on Zoom, you say, is there an empty chair that would otherwise be filled if someone knew that I was going to bring this issue up at this meeting, right? If the answer to that is yes, then absolutely don't bring that item up that evening and particularly act on it, right? But even short of that, recognize that the transparency expectation is people assume and expect that when you publish an agenda, that that's the business you're taking up and no more than that. So it's important. And it also has the great effect that once you have your agenda set, that's where you can focus your resources for that evening or for that meeting, okay? Use and expect civility in your meetings. I know that the local government level, we kind of pride ourselves in being approachable and in certain ways being informal, but I think some air of formality is still important. It still is the meeting it's still a governmental meeting, right? And so we want to conduct ourselves that way. We want to use and expect civility. That's true with respect to everyone from every direction. We want to show civility towards citizens who are participating in the meeting, towards each other as fellow board members in the meeting, and towards staff who's there with us in the meeting. Have some degree of formality, whatever that looks like to you. It's a little different on Zoom than in person, but same kinds of things, right? When you're receiving comment, for example, standard practice is remind individuals, hey, direct your comments to us as a board or commission. Have people be recognized by the presiding officer before they speak, those kinds of things. Also talk about and have a system for how you deal with public comments. And be consistent in how you sequence things, right? If it's always a practice, my apologies. It's always a practice that when we call up an agenda item, we have first the staff presentation and then the presentation by an applicant. If there's an applicant, then we have public comment. Imagine how unusual it would seem if we switch that up at the last minute for some particularly controversial topic. Or imagine how disconcerting it is to a citizen if for each agenda item, it's a completely different order of doing things every single time. So have some consistent sequence for those things, and then have a plan for handling disruptions, okay? Whether you're the town board or you're a commission or committee, find some time as a group, preferably at a time when all 5 or 7 members are there, to engage in some self-examination if you're having problems at your meetings, right? And that is to the point of making sure that the voices of the minority are heard. If you have even one member who's expressing frustration to the presiding officer that, hey, I don't think the meetings are going well because the discussions are being dominated by 1 or 2 individuals, and I feel like I can't speak or no one's getting equal time. We need to find a way to resolve that, because in a 5 or 7 member group, shouldn't everyone have an opportunity for equal participation, even if they don't take that opportunity, right? Shouldn't we always be welcoming of input in a respectful tone? Another thing we see quite often is, a frustration over there's lack of focus, right? What are our tools and techniques for staying focused on the agenda item that we have in front of us and the particular item that's up for our recommendation or our direction or our action? And that's a limited type of things, but we have seen a lot of questions for us at CIRSA and frustrations expressed around, hey, there's a lot of leakage. We started talking about topic A, and before we knew it, we were on the topic X. How did we get off the rails there? And I think those are issues that you as a board, commission, committee kind of own. And you owe it to each other to take time for self-examination on those kinds of things, okay? this will just tie up this suggestion with our best practice at Source is a suggestion that you find time as a board to discuss and develop certain norms around how you deal with meetings issues and common meeting problems, such as how do we handle public comment period? How do we identify future agenda items? Right? How do we give direction? Right? If we would like our liaison to bring us back some information about a pending policy issue, does each and every one of us give direction? I want you to do this, I want you to do that, right? No, I think your ordinance is, and a general principle is that your liaison, right, is accountable to the group as a whole. So we give direction as a we, not as an I want you to do that. It's we as a board, we as a committee would like this information, so on and so forth. Another thing is a wise board understands and has common agreement on how they deal with things, particularly use of staff time outside of meetings, right? How do we handle pre-meeting questions? How do we handle requests of staff for information? Right? I think it's unfair to your fellow board members and to your staff that if you have something on your mind that you want from staff, to not bring it up at your meeting and then bring it up directly to staff outside of the meeting, right? If you have a question or a request for information as an individual, really you're doing that as part of your service of the whole group. So you ought to be asking those questions during your meetings collectively to confirm whether or not the group collectively would like that information or would like that assistance from staff. Okay. Any thoughts, questions on those aspects? All right, let's turn to ethics real quick. Given the time constraints that we have, I'm just going to touch on ethics briefly because that could be a whole nother training topic. But I do want to remind you all that as public officials in Colorado, you're all subject to the Colorado State Code of Ethics that provides standards and requirements for public officials, okay? Among the main ones there is a conflict of interest rule under state law that applies to each and every one of us, right? But if you're on the town board or a board or commission, you essentially have an obligation, a legal obligation to step aside in matters involving a conflict of interest. So let's remember when I have a conflict of interest. If I as a board member or a committee member have my own personal financial interest is going to be affected, right, by some decision that my board is going to make, and that includes even a recommendation, then I'm in a conflict of interest situation. So let's, for example, let's say we're on the planning commission and the item that's up for consideration is a rezoning. Well, if I'm half owner of the property that's going to be rezoned, I'm in a conflict of interest situation, right? Absolutely. So when that matter comes up, what do I need to do? I need to disclose at the public meeting, at the outset of that agenda item, that I have a conflict of interest. So I'm going to say to the chair, before you start talking about this rezoning, I have to make a disclosure. I have a conflict of interest in this matter. I'm going to step away from the board's discussion and vote. And then you're obligated to step away and not participate in the discussion or the vote, okay? And also you're obligated to not attempt to influence the other board members in their decision, okay? This applies at all levels, town board, commissions, committees. I'll give you an example at an advisory level. Let's say for the Trails Committee, right? We have maybe part of the Trails Committee's charge is to develop the trail master plan. And that includes maybe some element for trailhead signage. And the board saying, hey, could you give us a recommendation on just some general themes for broad design themes for trailhead signage? And if you say, you know what, great, I'm glad we got that assignment because my wife actually is in the sign business and I think she would do a great job designing signs for us and giving us some overall themes, but we got to pay her a little bit. Is that a conflict of interest situation? Absolutely. Same principles apply. You have to disclose you have a conflict of interest, step away from that, right? So on and so forth, and not attempt to influence others, okay? The other thing is to remember on ethics is once in a while, more so for the town board than the other boards and commissions, but once in a while, you're going to come across confidential information. You have a duty, right, to make sure that you do not use confidential information that you gain as a public official for your own personal benefit. So be very cognizant of that. If you have any questions about whether this or that piece of information is confidential, ask Angie, ask staff, right? Hey, this document we got by email, is that deep background? Is that work product? Is that confidential? And recognize that your board, if you have a piece of confidential information, then it's your board as a board that needs to make the decision of whether or not that information is going to be released. Okay.
We have a question here for you, Sam.
Yeah.
We're just wondering, should they leave the room or leave the meeting discussion physically if there's a conflict of interest?
The short answer is I would recommend yes. To be fair to you, I will tell you the state statute doesn't absolutely require it, but I would recommend you do that because I'll give you an example where that can become problematic for you individually. Let's say you don't leave the room and they're discussing your interest. I'll use my rezoning example. If I say, hey, fellow trustees, this is my property that's being rezoned. So I understand I'm going to step aside, but you stay in the room. Right? What if a question comes up for the applicant? And you say, oh, well, I'll answer that, right? I can answer that. I can tell you how big the property is, right? But then I say, well, the property is a couple of acres. Oh, and by the way, you know, it should be rezoned because it is a couple of acres, you know, and it's large enough to accommodate a couple of dwelling units. And so I don't think it should be zoned agriculture. In fact, I think it'd be a great piece of property for residential development. What have I just done? By my comments, I've now probably influenced, right, my fellow board members. The last obligation under the statute is that when you recuse yourself, you are required, right, to not attempt to influence the decision makers. So I don't want you to be in the crossfire on that. I don't want there to be some misperception or accusation that you stayed in the room and even under the guise of answering a question, you somehow attempted to influence the other decision makers. So I want you to be protected. So I think you're best protected if you simply remove yourself entirely from the discussion and from the room where the discussion is occurring. Now, some people say to me, that's unfair. That's my property. I have a constitutional right to represent my interest in my property. And my answer to that is, well, that's true to a point. And here's where that point is. You have absolutely every constitutional right to represent your interest in the property, but you also are a public official. And that's just the way the rules work. So you got to make those, you got to reconcile those two things, right? Okay. Does that answer that?
Oh, sorry.
Yes, sir.
I probably should have let you finish.
Oh, no problem. I'm ready. Did you have a question on that?
Well, actually, we had a question in the chat. Carolyn, if you want to just unmute, you can ask.
Hi, Carolyn.
Or you could throw it in the chat and I could read it.
Oh, is it in the chat? Should I look there?
Yeah, can you hear me now?
Yes.
Yes.
Yeah, I'm sorry, I'm not a public official. I write, I've been reporting on the Board of Trustees actions on a lot of issues and things, but I was following up on Trustee Lou's question about Facebook. It seemed to me that I heard you say that you gave the green light for, what was it, 2 or 3? It's okay if like 2 or 3 trustees could join a Facebook. We get lots of comments. We've got lots of comments, like on this last story on parking, the managed parking program. Lots of comments, and what I want to know is, were you saying that it's okay if like 1 or 2 or 3 trustees join in and discuss, or is there is that going to be a problem? As long as there aren't 5 of them talking about it, as long as the comment section there's only like 1 or 2 trustees that appear in the comment section on this topic. And then if the subject was a trails story, one or two could comment, join the discussion on that.
It's going to be fact specific. I'm sorry to do this, but I'm just going to return back to the rule, and maybe it's just taking time to digest the rule and how it might apply in any particular fact situation. But the state law says that if 3 or more trustees have a discussion of public business by electronic means, then that has to be an open meeting. Now, so the question becomes, in a Facebook posting situation, are 3 trustees discussing a matter of public policy with each other? On its face, when you have comments that dropping down in a Facebook thread, right, it may appear that they're not talking with each other, right? But the risk I see for the public officials is if there's a number of comments going back and forth in the thread, and more of them seem to be giving comments to each other about that item of public business, then I think we're getting into concerns under the open meetings law, right? And the other issue that comes up is, well, that people may say, well, that's not a problem because it's an open discussion, right? But Facebook isn't truly an open forum like a duly noticed public meeting, right? So that's the concern I have. I think more practically in terms of committing ourselves to transparency is as elected or appointed leaders, we have great processes that we've already developed for having discussions around our public business, and social media just simply isn't really the best platform, right? It's not a town-sponsored meeting. It's not a town-sponsored platform. It's not something that a forum for which we give notice, right? So be a champion of the procedures that you have in place already, and commit yourself to honoring that this is where we as a board discuss important town issues. And that's at a board or committee meeting that occurs after the clerk gives notice and we all jump on Zoom in a duly noticed meeting, or we all meet at town hall for a duly noticed public meeting. I just think in the larger picture, particularly on controversial issues, that getting on social media and engaging in ad hoc commenting about things that are on your agenda just is not a good way to have the board discussion of those. Yeah.
I'm sorry, but what if it was just like one trustee, one designated trustee to talk, to answer and not engage, but just to answer constituents' questions, not engage, but if that's what I guess I'm looking at.
Yeah. So I don't know. It depends. First of all, would the board really want to do that? There are some dangers that I see. Number one, I do think if you're commenting, you are engaging, right? You're engaging. Comments are engagement. Facebook comments are engagement. For reasons that I haven't got to yet in the presentation, I don't think any trustee individually should ever engage on social media regarding a quasi-judicial matter, right? I mean, like a land use application or a licensing matter, and I'll get to the reasons why in a minute. But they have to do with due process issues, right? And so then I think the question becomes, do we want to designate someone to speak for us on social media? I think the question becomes, well, what's the platform? Do we already have a town social media site, right, where staff is already doing our speaking for us, right? If I'll give you an example, if we have a high profile controversial project, or maybe it's a controversial, maybe you're building a roundabout, right? And we want to get the town's information out there about the roundabout. What's the best way to do that? Put up on your website, your Facebook page, your town-sponsored Facebook page, your town-sponsored website, the town's collective voice about that project, right? That's not to say that I get it that individual trustees may still want to respond to a Facebook thread about when they read a thread that says, oh, this project's a disaster, that they might want to say something, and they may have the right to do that. But I think the point of firing on our cylinders is, if I'm doing that, is it consistent with the information that the entity I represent is putting out? Am I accurately reflecting the status of the project, right? Are we as an organization consistently messaging the status of an issue or the position of our board or committee? I think there is kind of a fiduciary obligation to make sure our message is accurate, at least in that regard, right? I get the fact that people have purported First Amendment rights, but I think your question was in terms of when I'm representing the entity as an entity, how should we do that? And I would recommend to you that if we've identified an issue that's worthy of some social media communications around an issue, think about using the town's operated and maintained website and its related social media feeds if you have those, right?
I totally agree with everything you say. It's just that, first of all, I think that the town is still training people to get onto the website. If they don't really, I don't know if a lot of people really know to go there. A lot of times people get up in the morning at night, and the first thing they do is have their coffee and look at Facebook. The second thing is that I just, if I were a trustee, I would feel sort of at risk because a lot of people just feel that they aren't, that the trustees just are holding back. They're not listening, they're not responding, they don't care what they have to say because there's no response from them on Facebook. I'm not saying that, I think the trustees have been very responsive, but for a lot of people who read Facebook, they don't get it. So that's my only answer. I'm just, yeah.
Yeah. And so, yeah. There are all sorts of tools and techniques around that, but I think your last comment highlighted the point that I made that social media is not necessarily the best platform for a discussion of the board's business because it's a deliberative process. You as board members and elected and appointed officials need to take the time you need, and sometimes that doesn't move at the same pace as social media, but as part of your responsibility to the town and the community as a whole, you're going to take a more measured approach, a more deliberate approach, and sometimes that's just not consistent with the demand that I get an answer right away just because I put a comment up on Facebook. But I get it that if there's a lot of that kind of traffic going on, then we as an organization probably step back and say, hey, to our manager, hey, we're seeing a lot of inquiries, I'm hearing a lot of inquiries about this project or this or that. Can we put out some official town information that at least helps answer questions about what is the status of this project or that particular matter, and rely upon your staff to help you do that, right? Every community's got high profile issues that end up getting up a lot of traffic on social media. And my suggestion as an organization then is if it rises to that level, then use your own platforms and your own tools, town-sponsored tools to put out information about those.
Thanks.
Thank you. Okay, I think we're done with the ethics piece. Let's keep rolling here. I put up here some scenarios that I think we won't go through, but just something to look at when you have a chance. I think based on the comments that I made about how to handle conflicts of interest, the answers to those will become evident. Let's talk about, my next suggestion is to support the town's structure. And now I'm reaching back to just unpackage a little bit, something that I started with at the beginning of the presentation. And that is, no matter how large or small a municipality, everyone within the organization has a job description. I want to cover kind of the legal side of it first, dispatch with that, and then talk about some suggestions, tips for success around these issues. So from a legal perspective, right, everyone within the organization has certain powers and duties, right? And that means that there are certain other powers and duties that they don't have. And that's very important to appreciate that from a liability concept, because you're protected as an individual public servant, right, from liability so long as you're acting within the scope of your employment and not acting willfully and wantonly. The scope of employment means I'm protected, right, and you have insurance coverage for claims, right, when you're acting within the scope of your employment, right? The examples aren't always this easy, but if you have a town marshal, right, then who's responsible for writing tickets in the court? The town marshal, right? The corollary of that is who's not, right? The other the elected officials, and that's more than obvious, right, on its face, but it does have a liability tinge. And to take even such a simple example to drive the point home, we have had claims over the years where the claimant says, yeah, I get that the marshal's the one who writes the tickets, but what was really going on in this city or town was that there were elected or appointed officials telling the marshal to write tickets. Does that sound good? No, right? So that applies all levels, all directions throughout the organization, right? Elected and appointed officials have a particular job description. Staff has particular job description. So everyone needs to know and respect their job duties. An obvious point, but what I need to touch on from a liability standpoint is this concept of willful and wanton conduct. Willful and wanton conduct is simply conduct that's intentionally undertaken, that's intended to harm someone's protected rights, and that's undertaken with deliberate indifference to what their rights are. That basically means malicious conduct, right? Doing bad stuff. That means from where you sit as an individual elected or appointed official, it simply boils down to this: do not use your cloak of governmental authority to do the wrong things to people for the wrong things, for the wrong reason, you know? Like use your cloak of governmental authority to make sure that some business competitor of yours doesn't get a business license, right? That sound like bad stuff? That's bad stuff, right? And that's where you can lose the protections that you have. So getting away from the legals to the more practical stuff, everybody's got a job description. Every committee, every commission, and every member of the committee or commission has a job description. Where do we find those? For other than the town board, they're primarily in ordinance number 2020-03 that talks about this is the role and responsibility of the Parks Trails Board. This is the role and responsibility of the Fire Committee. This is the role and responsibility of the Planning Commission, right? And you can see, plugging into the concepts I just mentioned, that there are limits on people's authority. On the bottom of the slide, you'll see here, for example, that it says that no member of any board, committee, or commission has the authority to act on behalf of the town, right? Including approving contracts, negotiating deals, spending or allocating town funds, right? To the extent that any board or committee has a role in making an advisory recommendation, then how do they do that? Collectively as a we as a board make this recommendation to the town board. So that ordinance shows you what the limits of the authority are. It's important to respect that. It's also important in terms of committing. That's how we as an organization decided to set things up, right? So we want to concentrate our energy and spend our resources within the areas where we have authority and where we're asked to do things on behalf of the organization, okay? Make sure, except for the town board, all the boards and commissions are advisory, right? So you want to be careful in terms of understanding that piece. I know there's a temptation sometimes, and I know there's an expectation sometimes of citizens that they'll approach you if you're on one of the advisory boards and say, people want to know, well, where's this going? What's going to happen, right? But you have to be careful, protect yourself, be protective of the town by reminding people that, hey, my board or committee is simply making a recommendation. I can't really tell you ultimately what the town's going to do in this case. It does have a risk tinge to it because sometimes people will come to your board and committee and they think that after you make your recommendation that it's a done deal, right? But it's not a done deal. The town board still has to act, right? And also internally, you owe an obligation to the rest of the board members that if, like, let's say we make a recommendation to the town board, but it's a 3-2 vote, right? If I was on the 2 side of that vote, I have to respect the fact that what happened was we made a recommendation that's consistent with what the 3 wanted, not what the 2 wanted, right? You don't have to be a cheerleader of that recommendation, but I think you have to honor it, right? You can even tell your constituents, well, I wasn't in favor of the recommendation that was made, but the recommendation that my committee made, that we as a committee made, right, was to do X. And I think that's an important responsibility and trust that you have in one another to do that, all right? To protect yourself from risk, recognize that your role as an elected official or appointed official is a group role, that you do your job primarily by meeting as a body, right, in a duly noticed public meeting and voting on issues that come in front of you via your agenda, right? And that's a great place to be, particularly from a liability standpoint, from an attorney standpoint, because it's very clear then that you're doing things collectively. It's very hard for someone who's angry with you to try to pick you off individually, right? if you're just doing what you're supposed to be doing as a board member and contributing your voice to the work of the board, right? Recognize that in doing your job, you're thinking in terms of we as a board, we as a committee, we as a commission. If you find yourself thinking in terms of I, that's a red flag, both with respect to your role and with respect to potential risk issues, right? If the attitude is, well, I don't like the recommendation, you can do what you want, I'm going to do this, that's a red flag. That's not consistent with the role and authority of your board, right? And in a tough situation, it can create a liability risk if you go out and do something on your own, okay? All right. These concepts are, they're also particularly important in the employment realm, right? Recognize that you have the most common system of government that we have in Colorado for municipalities, and that is you have a board manager form of government. And that means the board has decided to create a manager position where it is delegating to the manager and has delegated to the manager, right, responsibility for supervision of the staff, right? And that means that the manager is responsible for the supervision and direction given to employees. In fact, your ordinance for your boards and committees says, right, that board and commission members do not give orders or direction to staff, right? What they do is the fun stuff. You develop policy, by they I mean you. What you do is you do the fun stuff. You develop plans, policies, vision, stuff like that. Your manager does the day-to-day heavy lift of supervising employees, right? Couple of comments for the town board members. Of course, there's an exception there. The town board does supervise a couple of people, right? But the town board only supervises the manager. Do you have a judge? The judge and the attorney. Is that it? That's probably the town board's 3 direct reports, right? So that's where the town board spends its energy as far as being a supervisor, right? But no elected or appointed official should misperceive that part of their job is to be a super manager or a micromanager, right? The allocation of responsibilities is set up again in terms of the boards and commissions and legislative and policymaking bodies. They do the fun stuff, and you leave the day-to-day supervision to your staff. Rest assured, that does not mean there is not accountability. Your manager is accountable, but your manager is accountable to the board as a whole, right? And to the extent liaisons are looked to by our board and committee, their responsibility is to serve in a liaison capacity to the board or committee as a whole. And that's why we is so critically important to these issues, that we act and we interact in terms of we, okay? I recognize, by the way, just closing out that last comment, I recognize that once in a while, you may be approached by an individual employee who wants to talk to you about a personnel matter, right? But you do not want to get involved in that. You do not want to reach down into the chain of command or allow others to reach up through the chain of command, because that could be destructive to the organization. Now, I get it that sometimes an issue may crop up that needs some attention, but it's not the attention that it needs is from your town attorney or your town manager or a department head, or in a real tough situation, the town may want to reach out to SURSA, but it's not a situation where you want to jump down and get individually involved in a personnel matter, okay? Recognize that I get it, well, your board's made up of 5 or 7 individuals. It's not, right? A group of people giving 5 different directions or suggestions to staff, right? Or to your liaison. You need to resolve to speak with one voice to your liaison or to the manager, or whatever the case may be. Recognize that if you're not the chair, then it's, if you're in one of the advisory boards, then it starts with the chair being the point of contact, right, with the staff. And each member has an obligation to honor that, okay? Lastly, I don't harp on this too much, but there is absolutely in every organization a distinction between policy, right, or legislation and administration. And organizations that function on all cylinders, they recognize that. commit themselves to that allocation of responsibilities, right? I think, for example, for the town board, your ordinances say that the town board is the legislative body within the organization. It makes laws. It adopts ordinances. It deals with broad policy issues. It deals with certain decisions like licensing that are within its bailiwick, but it has already said through its own structure that the day-to-day operations are handled by staff. I think a good way to look at that is in terms of this chart here, right? I'm not sure this is not in the materials that you got with your packet. But, in preparing, I was thinking about this. For the leadership groups, the advisory boards and commissions and the town board, where are we spending our energy, right? You as the elected and appointed officials, you're the ones with the broadest vision and the longest time horizons. Your duties are particularly focused on the grand scheme of things, master planning, long-term vision, the budget, 5-year capital plan. Where do we want this organization and community to go? You're interacting with the owners of our organization, the citizens, in trying to figure out what are the wants and needs of our community and how can we put governmental resources on here, on those things. So that's where boards and commissions spend their energy, is on leadership and resourcing, ownership and governance issues, and then leaving your management, supervision, and frontline employment issues to your staff. So, any comments or questions around those issues?
Hi, this is Margaret. I just have one real quick question. I think it pertains to what you were just talking to. How do we handle it as a board collectively if we've got 1 or 2 constituents that are reaching out to only 1 or 2 board members with issues, but then they bring whatever the issues they have, they bring it to the general meeting, not the board member, but whoever's reaching out? How should, as an individual board member, how should you respond or react or not react when somebody's reaching out to only you?
There are a lot of dynamics to that. The starting point is, why are they coming to me only? And do I have the power to help them, or is this a board issue? Right. And I get it. I mean, people who, and citizens, naturally, as they will and should probably, if they're looking for a particular action from their elected leadership and they believe a particular official is aligned with their views, then they'll probably approach that person first, right? But ultimately, to achieve a particular end out of a elected or appointed body, it's a decision that's owned by the entire body that has to make that decision, right? So I think it then becomes a question of, where does that issue go from here? From a risk standpoint, I want you to protect yourselves. And if it's one of those, the dynamic is really someone's coming to you because they don't know where to go, but you're sensing or getting this vibe that they're coming to you for an answer, and they think that you alone can give them the answer, then I want you to protect yourself by saying, dear citizen, that's an interesting issue. I have my own views on that, but I really can't help you individually. That's a decision that has to come in front of our board or the town board or the commission, right? Or if it's an administrative matter, right, then don't elevate it to a town board or a committee issue. Say, well, dear citizen, I understand what you're saying, but actually it's our building official that deals with building permits. So I would recommend you go to town hall, touch base with the manager and staff there, and they will let you know what the process is for dealing with your building permit issue. So I get ultimately that citizens and constituents who are aligned with you on a particular matter will start with you first. But the question ultimately becomes, however it comes forward, is this an interest that the board has? And is it going to become part of the board's items that it's going to take up, right? That ends up being a discussion about priorities and agenda and where you're going to spend your resources and where's your work plan and things like that. Because over the years when I was a municipal attorney, many times I saw people come forward, even during public comment, or an elected official come forward and say, hey, a constituent said we need to spend some time around this issue. And you all then have to have a discussion of, is this on our agenda this year? Is this part of our work plan? Do we want to pull staff off of X, Y, and Z so they can attend to this issue? It does have resource allocation aspects to it as well. So I don't know if others want to add anything to that. Angie?
Sorry, I'm having some technical difficulties over here. You know, I think the separation between policy and operations is so important, not only from a contract management perspective. You know, when we have vendors in town, managing those contracts and such, that definitely needs to be done by staff. There is a dollar figure attached to that, and the staff are the ones that are recommending to the board that those contracts are paid with our accounts payables when that bill comes due. And we need to be able to confirm that, and to make that recommendation, we need to be able to confirm that that work has been done to the level it's appropriate for to satisfy that contract. There's a number of other things I could say here, but policy is the fun part, and the operations of what goes on day to day is that's what you hire us for. That's what you have us here to support you for, and things can run very, very efficiently. And we are a lean government, so the more efficient that we can use our time, the better. As staff, right now we're only 2 people on the administrative team, and that's not very much for what we have to do. So as you can see, we're often working till sometimes 9, 10, 11 o'clock at night to get it done. And there's not the funding to hire additional employees really to help with that. So that separation of policy and operations will actually lessen the workload, because management will be able to manage these things in a more effective manner.
Second.
That's my soapbox.
I second your soapbox, because I couldn't agree more. I don't have much to add past that.
All right.
Now, we do have another question in the chat real quick, Sam.
Yeah.
David is asking, what are accounting expenses compared to budget? Oh, I don't know if this pertains necessarily to the presentation or if this question's for Sam necessarily, David, but we can ask it. What are the legal requirements for the BOT to provide an accounting of expenses compared to the budget?
I could actually jump in and just say Title 29. Title 29 is the state statute that governs budgeting in the state of Colorado. And if you're interested in that, it's out there, and it's a pretty big document. You know, DOLA, the Title 29. There you go.
You all on the Board of Trustees, I'm sure have heard this old saw. The budget at the end of the day is a policy document. By what elected body does through its budget, it expresses policy for the upcoming year, right? But I find that the allocation between policy and administration is best served when those responsible for the adoption of the budget are focusing on the broad policies that they want to express through the budget for the upcoming year. And then once your budget is adopted, that document really does reflect the direction that you've then given to staff. This is where the resources are going to go in the coming year. You then have hired professional staff consisting of a treasurer, manager, finance staff, if you're fortunate enough to have some finance staff, and auditors and so on and so forth, who are responsible and have a duty, right, to make sure that expenditures are made in accordance with the budget and the purchasing policies, and that there's an accounting and reporting system for all of that. So for elected and appointed officials, you want to focus your energy on the going in discussions around the budget, the ones that go on in the late summer and fall about how do we want to plan for the following year, right? And then you have to have faith in the systems that you've already established, that you have competent professional staff to carry out the budgeting detail obligations as they unfold during the year, right? So I think I don't know if you're like some entities that go through the bill run every meeting, right? And you can do that, but if you're spending enormous amounts of time just vouching expenditures and you've only got 3 hours twice a month, then are you building in enough time to deal with the next round of broad wants and objectives and policy perspectives that are great places to be in terms of how you spend your energy. So, yeah. Okay. And then your manager and staff are, I get it, you know, at the beginning of the year, you have a budget and it says, let's do A, B, and C. And by June, there's a push by a majority of you to say, well, we ought to add D, E, and F, right? Your manager and staff know what needs to be done from a budget perspective, right? They're going to tell you, well, if you want to do that, we have to find the dollars. So we're going to have to come back to you with a policy question of whether you want to do a budget amendment or not. But that's a board decision that gets queued up as a policy discussion. All right, well, I'm done with the budget discussion. My last suggestion, whoops, is real quickly, I know I'm running over time, so do we have folks from the Planning Commission and Board of Adjustment here as well? No.
I believe so,
Yes.
yes.
Okay.
Yes, we do.
All right, I'm going to make this real quick and go through these slides real quick because we do have through our social website a webinar that you can watch that handles these points in a little more detail. But I want to just remind you all, for the town board, the Planning Commission, and the Board of Adjustment in particular, recognize, right, that part of your job is you're going to be making decisions once in a while that affect people's protected property rights. When you're on the town board, once in a while, you're going to make a decision about a license, right? Or if you're on any of those three that I just mentioned, you're sometimes going to make decisions about people's property, a subdivision, a zoning, a conditional use permit, those kinds of things. When you are doing that, you're making decisions affecting people's property rights. And we all remember the due process clause. No person shall be deprived of property without due process of law, right? When you're making those decisions at a local level, that clause kicks in, right? And we're responsible at a local level for making sure that we give people due process. That's the way we want it to be. We want this power locally, right? We want to make land use decisions and licensing decisions at a local level, right? But that's an enormous power, right? And only 5 of you have the power to make a recommendation on something, and only 7 of you in this community have the power to make the final decision. But with that power goes the absolute responsibility to give people their due process and make sure that you walk and talk, right? Walk the walk and talk the talk in terms of honoring their due process rights. That really means you need to approach that decision making just like a judge. That's why we call it quasi-judicial. Because when you got a land use application or a license application, here's the requirements. We can only make that decision, right, through a public hearing process where we give everybody notice that we're going to have a public hearing, right? And we're going to make our decision based only upon the evidence that we get at the hearing. Everybody comes in and tells us about the application, right? And the only factors that are important, right, in making the decision are what are the pre-existing criteria that apply to making this decision. If it's a rezoning, we know what the criteria are, right? They'll be in the staff report. If it's a liquor license, we know what the criteria are. They'll be in the staff report. There are things like, is the proposal consistent, compatible with the neighborhood? If it's a license, is the applicant of good moral character? Those kinds of things. We can't make due process decisions. Due process decisions are not a popularity contest, right? And they're not a platform for expressing our own personal views. And I'll give you an example on that. Let's go back to our rezoning. Let's say you got a rezoning in front of you, right? And you say, we had a great public hearing, and you know what? But Madam Chair, I'm just going to recommend we vote no on this rezoning because, I just don't like the applicant. Is that an applicable criteria? No, right? We must stick to the criteria that apply. So keep that in mind, right? In that particular role. Oh, let me keep going here, right? It doesn't mean there aren't rules, right? But it means that as the judge is making that decision, we can only base our decision on the rules that actually apply. Some of the other important things is make sure you don't engage with people about a property rights matter outside of the hearing. I know that can be tough, right? I know that sometimes you got like a high profile application in front of the planning commission and there's a lot of community interest in that and people want to call you on the phone and say, hey, planning commissioner, can I talk to you about this application that's going to be on the agenda next week, right? Think of it in terms of this. If that were your application, would you want the decision makers talking with somebody on the side about your application without you knowing, without you having the ability to respond to what's being said? Now you see how the due process clause applies. That's why you're not allowed to engage with people outside of the discussion. It's not that we don't want to hear from the citizens, right? We just need to remind them, hey, as the decision maker, I can't have a side discussion with you about this application outside of the hearing. We'd love to hear from you, but just please come to the public hearing. If you can't make it to the public hearing, you can send in comments and I'll give them due consideration as part of the decision, okay? Is that important? Absolutely, critically important, particularly for this liability reason. If we do not honor someone's due process rights, the corresponding civil rights remedy applies to each and every one of us individually, and the potential liability is our own individual liability, okay? We have insurance for that can help protect you, right? But if it's a real bad situation, if you're kind of going off script and going way out in left field and doing bad things like, for example, hey, I get to make the decision on this rezoning, but I really don't like it. So maybe one of the things I'll do is beat the bushes and make sure I get a lot of opponents there, right? Or maybe I don't like this because they're my competitor, but I'm not going to step aside because of my conflict of interest. I still want to make sure there's a no. Those are bad situations where the civil rights risk, the due process risk can attach to you individually. So be very careful in that regard. On this slide, just to finish up, at the bottom here is a link to a recording of about a 25-minute webinar that I put together to help familiarize you with the due process rules of engagement. So if you have time, take a look at that video and that will help you, okay? The last thing I want to say on quasi-judicial stuff is make sure that when your hearing is over, at the end of the hearing, whether you're getting ready to make a recommendation to the town board or you're the town board getting ready to make a decision, it's always good to have a discussion of why you're going to vote the way you're going to vote, okay? Because in doing that, what you're doing is you're making a record of why you're going to decide the case the way you're going to decide it. Sometimes it doesn't get off to a great start. You know, maybe the rezoning hearing's over and somebody says, well, I'm going to vote no because I just don't like the applicant. That's not a good start. But at least we're going to deal with that issue, right? Because your staff's going to say, I'm sorry, that's not one of our criteria. Oh, okay, I get it. Well, let's focus on the criteria, right? And then somebody says, well, I'm going to vote no because I just don't like it. Maybe somebody else can help them by just asking them why. Well, why don't you like it? Well, I don't like it because it's incompatible with the neighborhood. Now you're starting to have a good discussion about what the criteria are and how they apply. So this slide here is intended to drive home the point that it's always good to have a discussion of the standards and always make a record, have an open public discussion about why you're going to act one way or the other in making a decision, okay? Do you have any questions on due process stuff? I know I covered that super, super quick. But if you have time, I'd suggest taking a look at that video. Any questions or particular issues around that you're struggling with now? All right, I'll wrap it up for you. My suggestion 7, it goes back to kind of getting back to the 40,000 foot level, right? It's a wise elected or appointed board that uses its power wisely and humanely, right? recognize in the big picture that you set the tone for the whole organization, for the entire town of Green Mountain Falls in terms of how it treats its employees, how it treats its citizens, how it treats its business community, right? Understand always in every setting, in every interaction involving the town, that you're perceived as holding powerful positions, the most powerful positions in local government, because you do. And so it's important that we carry ourselves and conduct ourselves appropriately to that task and to that responsibility. Use courtesy, tact, and diplomacy in your interactions, particularly in public settings, right? This does have a risk aspect to it, because we can see claims that surface every now and then where the underlying issue is there's a sense that the elected or appointed officials were acting in a retaliatory manner, or they overreacted and they somehow were retaliating against someone for the wrong reasons. So I know sometimes that things can get a little heated, right? And the temperature can go up a little bit, but I think part of the responsibility as public officials who provide good public process is to find good techniques to bring the temperature down. Recognize that we can be in a position where we're having good debates and healthy discussions, and we can have good disagreements and without being disagreeable with each other, right? When we come to debates with each other and with citizens, always assume and act for yourself with good intentions. Come to the discussion with good intentions, with courtesy, tact, and diplomacy, and recognize that local government is kind of avowedly nonpartisan, right? So whatever issues are out there swirling around, the partisan issues that are dominating the day, they don't have to inject themselves or infect the way we do business, right? It's a very wise board that figures out if we're having discord with each other individually, that we don't let that drive our decision-making or how we do things as a town. Finally, make sure that your meetings do everything you can to avoid the kind of surprises at your meetings. You know, meetings ought not to have this dynamic where it's kind of gotcha moments, right? As an elected or appointed official, I think it's always within your purview to make the tactful call to your town manager or staff if you're getting ready for a meeting and you have a question about the packet material, because that can help avoid not only the surprises or gotcha moments, but it can also give your manager and staff time to prepare to answer that question at the meeting, right? So I think that's just fine to use your manager as a resource in that regard if you're preparing for a meeting. Commit always to act as we. I think that's the overarching takeaway that I have for my presentation tonight, is to recognize that we as elected and appointed officials within our body, we act as a we, and we commit to serving our board, our commission, and our community. So with that, I want to thank you all very much for the opportunity to present and meet, check in with you all virtually. My last two slides are some resources for you. The town board members know this, but we have a handbook for you all that you can download through our websites. And again, at the bottom of the slide is the link to my quasi-judicial training. And then the middle link there is our executive director, Tammy Tenor, recorded a webinar just giving more suggestions for how you do your job successfully and have success and do great things for your community. So I'll stop there. If there are any questions for me, I'm happy to take those at this time.
I don't think we have any
While we're
questions.
While we're waiting here, and if maybe one or so pops in, but I just want to say thank you to everybody for coming and showing up tonight and participating. And, you know, we're always available to support you with questions for clarification on this stuff. Quick email, quick phone call, whatever you need. We're there for you. And if we don't know the answer, we have Sam's email. So. But thank you for your time, everybody.
Okay, so thank you. And again, Sam, thank you for your time. Thank you for the plethora and wealth of knowledge that you've provided for us. I am going to talk as an I right now instead of a we, because this is like my 7th webinar this week for training purposes. I think everyone in the world has May for training. And if we could just remind everyone that's on here where the resources are available from. And I believe the packet was sent out in the original email. Is that correct? For us to be able to download this presentation?
I think that, yeah, I had sent down my slides, and those can certainly be made available to make sure everyone has those. Absolutely. This
Okay.
handbook that's on the screen right now, that picture there, that's on the public facing portion of the SOSA website as well.
I have mine.
Yeah, yeah. Let me stop sharing my screen. Well, there we go. Well, that book was written particularly for elected officials. It does have information there that if anyone wants to go to sosa.org and then just put in the search feature, Elected Officials Handbook, there's a lot of discussion in that book around the dynamics of succeeding as a collective public body and how do we, as members and as a group, commit ourselves to best practices. So I hope that publication is helpful to anyone who wants to dive in deeper on some of these topics. So.
It is. It's a great little booklet. Now, also, the webinar link that you had referred to, was there a different one besides the one at the end of the presentation? Are there more webinars available, like through the site or something, or
Yeah,
you know?
yeah. For anyone who is interested in additional resources, if you go to www.sorsa.org, across the top on our homepage, there's a ribbon, and one of the tabs is Education and Training. If you click on that, there's a drop-down item for elected officials, and then that'll take you to our page where we've assembled all the information that we have for elected and appointed officials. And under the tab, whether you're an elected official or appointed official, you can find more information about meeting issues, about dealing with public comment periods, how do we deal with board dynamics, are there open meetings, open issues that I want to learn more about. There's even some links there to some funny videos, I hope they're funny, that are marketing folks recorded that tries to put a little bit of levity to some of the tough issues that you face now and then, because I know sometimes it's not always easy that you can be in contentious meetings, but we tried to give you some tips and tactics on how to deal with difficult meetings and those kinds of things. So
That's good. So does this count as an LEU in addition to a CEU?
I'll have to check with my folks on that.
I've gotten some LEUs before, so hey, you know, whatever we can get for training. And then the other question that I have for you is, if we have people that weren't able to participate tonight, and Angie, this is directed for you and Matt as well. If we have people that weren't able to participate tonight, do you have a way for them to go online to participate in the webinar or participate in the things and to be able to verify that they've done it, since we are kind of saying this is mandatory?
So we do have these will be posted, right? There'll be the agenda packet, the link to join the meeting, and then the video, just like with all the Board of Trustees meetings, and it's on the Board of Trustees page. It is the honor system, so we don't have a way to verify. Yes, yes,
okay.
Absolutely.
Okay, okay. So thank you. So yeah, thank you for your time, everyone. We appreciate you attending. And again, Sam, thank you for the great presentation. It's always really good to be reminded of the things that we sometimes forget about.
Well, thank you very much.
I think if no one else has any other questions or comments, I think it's time for us to just finish the meeting. So, okay, thank you, everyone. We appreciate you joining. It's 9/11, and this meeting is now adjourned.
Thank you. Good night, all.
Thanks, everybody.
Jesse, if you had asked while the meeting was still going on as an official meeting, maybe I could have played some guitar next time.
I see that there, man. We'll get that next time.
Next time.
Well, next time will be in person, so you can do it in person. Good night.
You know what? If you bring the tambourines, I'll bring the guitars. We'll play.
All right.
Sam's like, no way. Have a good one, Sam.